apologies for the IT glitch, and thank you. Good evening, everyone. Welcome to the 30th edition of the JHS Excellencia Series. I'm honored to moderate this session today, and we have a very we have an industry specialist, Mr. Ambar Gupta, with us. He is the head of legal team in NSE, and Mr. Ambar Gupta is a distinguished legal professional with over 25 years of experience in legal compliance and regulatory affairs. He's a specialization in the financial services sector. He's currently serves as a senior VP in NSC, and he oversees the litigation and dispute resolution, regulatory advisory, contract, and M&A there. Prior to NSC, Mr. Gupta has spent 16 years at Aditya Birla Capital, where he held a key leadership position, including head corporate legal company secretary and compliance officer. He also serves as a head legal company secretary at Aditya Birla Sun Life Insurance. Throughout his tenure, he led various high-impact legal initiatives, championed digitization, and played a pivotal role in the legal and risk mitigation. He has been recognized with numerous awards such as General Counsel Leadership Award 2025, General Counsel of the Year, ABG Legal Meet 2022, and Mr. Gupta is a law graduate, company secretary, and heads additional qualification, including the Diploma in Business Finance, Diploma in Cyber Laws, All India second rank he got, and Executive Management Program in FinTech from IIM Lucknow, and certification in International Arbitration. He is a fellow of Chartered Institute of Arbitrator London and actively contributes to industry bodies, legal committees, and academic forums. So thank you, Mr. Gupta, for joining the session. And let's begin. We are very excited to take a lot of informative insight from you. So yeah, over to you. Thank you.
Thank you. Thank you so much for giving me the opportunity and the invitation to be partner in this knowledge learning session. Really good to see that you are putting so much efforts in promoting knowledge management, and spreading it to a large community within your industry friends and all. So friends, I hope I'm audible and my screen is visible to all of you. Today I'll take you through an introduction on arbitration and conciliation. Basically, in my presentation, I'll try to cover some basic concepts, some case laws, and while conducting arbitration, what are the things that you have to take into consideration, the concepts, how the arbitration tribunal are conducted, how the proceedings are conducted, and some of the ways in which international arbitrations works, and also a brief overview on the conciliation part, right? So the very first is that we know that whenever there is a dispute occurs between two parties, there are several ways where this dispute can be resolved, which it could be through negotiation to conciliation, mediation, arbitration, litigation, right? So the first three criteria like negotiation, conciliation, mediation, and arbitration, we all call as an alternate dispute resolution, because these disputes are resolved outside the court of law. So today we will concentrate on the ADR mechanism, which is alternate dispute resolution, with specific focus on the arbitration. Arbitration, as you all know, it's just a method of resolution of dispute by a neutral third party. Now, if I go back to the history of arbitration, in fact, the very basics of the arbitration, if anybody wants to know, relates back to our panchayat system in India, where five panchayat people used to sit together, three people sit together, and they used to resolve those disputes way back in an Indian scenario in the village panchayat and all those. So this is similar to the institutional mechanism of arbitration, where one neutral person or three neutral persons sit together and resolve a dispute between two parties, which is the nature of a commercial dispute. Not all dispute can be resolved through arbitration, largely a commercial dispute. I'll take you through what are the resolutions which disputes which cannot be resolved through an arbitration. Then, of course, another form of resolution of dispute is through mediation also, where there is a professional mediator which tries to resolve the conflict between the two parties. Again, this is something which is non-binding. This is very voluntarily, and normally mediation precedes an arbitration. But you can also do a mediation during arbitration also. But typically, a mediation precedes the arbitration, and normally when the mediation fails, then comes the arbitration. And the third is the conciliation process, which is kind of somewhat related to a process of, again, informal discussion between the parties by a non-binding procedure, where a third party, which is a conciliator appointed by the parties, can assist the parties to resolve the disputes in a mutually agreeable terms of the settlement. So mediation and conciliation sometimes are interchangeably used because of they are non-being binding and there is a settlement. But conciliation is specifically covered under the Indian Arbitration Act. Mediation is not specifically covered, and now we have a separate mediation act which is already introduced last year. So these are basics of that. Now, before we go into the realm of arbitration and Indian arbitration, international arbitration, it's very important to understand that in the current scenario, from where this entire arbitration has come up. So the current form of arbitration, which the Indian Arbitration Act is the forms a basis, goes back to the New York Convention. New York Convention is basically nothing but it's a treaty which is recognizes the enforcement of foreign awards, and which is not properly known the New York Convention. And before that, it was the Geneva Convention. So this treaty was signed on 10 June of 1958, and this convention has now become a very important part of managing international disputes, international arbitration. So through this convention, there are countries who has adopted this New York, who have become signatory to this New York Convention, and pursuant to which all the countries which are signatories to the New York Convention, they are required to adopt a model arbitration law, which is based on UNCITRAL model law, and which gives enforceability of the foreign award. So all the signatories, all the countries which are signatory to New York Convention, all those countries are now required to implement an arbitration law in their respective countries, which gives certain provisions, specific provisions of giving enforceability of the awards which are being passed in these countries. And the model law, which is known, which the countries are required to adopt, is known as the UNCITRAL model law of arbitration. So basically, the UNCITRAL model law of the international commercial arbitration, as it says, that is a model law, and it contains all the provisions which is now forms part of the Indian Arbitration Act in terms of providing concepts which are taken from the model law. So there is a model law, and all the countries have now adopted that model law. Of course, they have customized for their respective specific requirements, local requirement, but largely the genesis, the basics, they fall from this model law, which has been adopted and which is coming out of the New York Convention. So it talks about the standard requirements of, the arbitration agreement should be in writing. There should be a party autonomy in the appointment of arbitrator. There should be fairness in terms of the resolution of dispute by an arbitration. There should be a limited court intervention with respect to enforcement of the arbitration award. So it establishes the fundamental principles for implementing the arbitration process in a fair, efficient, and predictive manner for all commercial arbitration. These are some of the list of countries who are the signatories of the UNCITRAL model law. Like from India, also signatory to the New York Convention and has adopted UNCITRAL model law. Then within North America, US, Canada, Mexico, Europe, it's all UK, Germany, France, So almost all the continents and all the major countries are now signatories to the York Convention, and they have adopted the UNCITRAL model law. So about 90 jurisdictions or 90 countries as of now has been party to the UNCITRAL model law, and they have also now adopted the model law. So if you will read the Indian Arbitration Act, if you read the Ireland Arbitration Act, if you read the English Arbitration Act, which recently got amended last year, most of the provisional, the substantive provisions will remain same in terms of powers of the arbitrator, independence, no conflict of interest, and etc. etc. Right. So that's from the basis and the core through which the current Indian Arbitration Act is also designed. And of course, the main purpose is that when the international, when the trades are happening internationally, and the countries are interacting together, the multilateral companies are dealing, they have some kind of certainty that if there is a dispute and an award is passed, they will be in a position to enforce the award in their respective countries once they get this award. Now, Indian Arbitration Act is also divided into two parts. Part one, which completely deals with the domestic arbitration, the procedure for appointment of arbitrator and all, and the part two that deals with the implementation and enforcement of the foreign awards, which I will take you through in the coming slides. Now, coming back to the structure of the Indian Arbitration Act. So it deals with the commercial disputes. So all kinds of dispute which are arising in a commercial contract and business transaction can be taken for resolution through Indian Arbitration Act. And as I mentioned, it deals with both domestic as well as international. Right. So domestic arbitration procedures are covered in part one, and part two deals with the enforcement of the foreign awards. Now, very important when we say that what kind of disputes can be undertaken through an arbitration procedure. So while general commercial disputes are very much can be taken through an arbitration, and as you see, most of the service agreement, contractual, commercial agreements, all kinds of licensing agreements, software agreements will have provisions for resolution of dispute through Indian Arbitration Act. However, there are certain set of disputes or issues which cannot be undertaken through arbitration. And some of these relates to, for example, matters arising out of fraud, matters which are related to criminal offense, matters are related to, say, Competition Act, matters related with securities fraud, matters with respect to patents, etc. So some of these matters related to other kind of criminal economic offenses, those types of matters currently are not permitted to be, or in fact matters related to dispute related to properties. So all those types of matters cannot be undertaken through a arbitration mechanism under the Indian Arbitration Act. So an arbitrator cannot be appointed to resolve any such disputes which involves these kinds of matters. While the overall approach for the arbitration is that it's an independent, separate proceedings, and there should be a very limited judicial intervention. But Indian context, courts have been very time and again have been interfering and issuing directions with respect to the arbitration proceedings, and there are certain provisions under the Indian Arbitration Act where reference to the court can be taken on a required or a need to basis on a specific matter, which I will cover in my coming slides. Now, as I mentioned that to you, all of you, that there are certain set of matters which cannot be undertaken through an arbitration. So this is the case law. If anybody is interested, they can read it also. N. Radhakrishna versus Maestro Engineers. This is a very important case law where they have clearly stated that any matters or any dispute where there is allegations of fraud or where there is involvement of fraud, those cannot be taken up for the arbitration. So very important landmark. While there are also new judgment which has come up that where there is only a mere allegation of fraud and there is no proven facts of fraud, etc., then still arbitrator can sit on those disputes and they can decide whether there was a fraud or not. So I'm not getting into those technicality, but typically where there are any frauds, etc., involved, those types of disputes are not considered for an arbitration. Okay. Now, the very first thing in an arbitration happens is about the appointment of an arbitrator. That how do you typically appoint an arbitrator? Uh, Arbitrator has to be neutral, as you all will be aware. He should not be connected with the parties. And the Indian Arbitration Act has now prescribed certain qualifications, criteria also, or certain requirements which an arbitrator has to fulfill, and he should not be considered as a disqualified. For example, he should not have any pecuniary relationship. He should not be working as an advisor. He should not be an ex-employee of the one of the parties in the dispute. He should not have advised the client earlier. He do not have any outcome benefit of the outcome. So all those things are there. So he should be a person who should be an independent person for the purpose of proceedings of the arbitration tribunal. Now, typically an arbitrator can be for the 1 or 3 or 5 or 7. It has to be always in an odd number. It cannot be an even number. Now, when it comes to the appointment of an arbitrator, there is always two ways where you can proceed for arbitration for an arbitrator appointment. One is in ad hoc arbitrator. When you say ad hoc arbitrator, it means that usually you will see an agreement where it said that in case of any dispute, the parties shall elect an arbitrator with a mutual consent of the parties. Then there is an institutional arbitration. Just a moment. So, yeah, institutional arbitration. So this is an example of ad hoc arbitration. There's a standard clause which you might have seen where that in the event is not settled. This is a very clause which deals with first you resolve amicably, then you go to mediation, and even if the mediation fails, then you go for an arbitration. So this is an ad hoc example of an ad hoc arbitration appointment clause where it said that in case of any dispute, the arbitrator shall be mutually appointed by the both parties. So whenever it means that it will be a sole arbitrator. And you can also have a clause, as you know, that there can be a 3 arbitrator where one arbitrator is appointed by both the parties, and both the arbitrator then appoint a presiding arbitrator, which is the third arbitrator. Normally, a lot of people make a mistake that even for all kinds of agreements, they put a 3 arbitrator clause. So practical experience, I can tell you, never put 3 arbitrator requirement because it becomes very cost and becomes very lengthy and expensive also. So only where the subject matter of the contract is of very complex nature, then only you should go for a 3 arbitrator. Otherwise, a sole arbitrator is more than enough for the resolution of a dispute. So I have seen in my own experience that many times there is a arbitration clause becomes a boilerplate clause and a copy paste job, and many times the 3 arbitrator clause continues. So even if there is a contract value of say supply of stationery or supply of consultancy agreement services or supply of simple service agreement, 3 arbitrator clause is there for resolution of dispute. So that becomes impractical to implement. So only where there is a very complex subject where the amount involved is goes into crores, involves a lot of technical analysis, then only we should go for a 3 arbitrator, otherwise sole arbitrator. Now this is an ad hoc. This other way for an appointment of arbitrator which goes for institutional arbitration. So institutional arbitration works very well in case of international disputes, in case of international contracts, where 2 parties are undertaking a commercial contract. Say somebody sitting in UK and somebody sitting in India, and they are doing a business agreement and they want to agree for an arbitration. So in such cases, many times they go for a neutral jurisdiction arbitration, and that too through for an institutional arbitration. So institutional arbitrations are examples are like Singapore International Arbitration Center, or MCIA, which is in Mumbai, or LCIA UK, or ICC. So these are institutional arbitrations. So when you agree for an institutional arbitration, then in that case, the appointment of arbitrator and the rules through which this arbitration will be done as per the institutional arbitration that you have agreed. For example, in this case, the clause says that dispute shall be settled by the arbitration by following the rules of Singapore International Arbitration Center, and the arbitrator will be appointed by SIAC. And so in this case, any dispute will happen, the parties will write to SIAC with this arbitration agreement saying that now the disputes have come, so we are recommending you to appoint an arbitrator. So SIAC will appoint an arbitrator, and the procedure will also be followed by as per the SIAC rules in terms of how the entire proceeding for an arbitration will be conducted, right? Third thing which happens many times is that what happens, there is an ad hoc arbitration, and the parties are unable to agree for a mutual or a sole arbitrator, which is a very common phenomenon in India in domestic arbitration, because the usual practice is that if I recommend Mr. X to be an arbitrator, the other party will say, no, we don't agree for Mr. X, then it will be Mr. Y. And dispute arose that who will be the arbitrator. In such cases, the parties can apply to the concerned High Court or the District Court for seeking intervention only for the limited purpose of appointment of an arbitrator. So that is called a Section 11 application. So one of the parties can file saying that dispute has arisen, we are unable to agree on arbitrator, so please appoint an arbitrator. So in that case, the respective High Court, they appoint an arbitrator from the panel of arbitrator typically that they maintain from the roster, and ad hoc they will choose someone, or they will say, okay, these are the 3 arbitrators, I'm appointing someone, and in case you have any no objection. So typically Section 11 petition is what disposed of. Many times, however, it is seen that during such cases, the parties goes into dispute and they start arguing, this contract is not valid, this arbitration agreement is wrong, etc., etc. However, then at that point of time, courts get into many procedural things. But as per the law, whenever such an application is made for an appointment of arbitrator, the court should only refine itself with the provisions that whether there is an arbitration agreement. If yes, then I will go and appoint an arbitrator as per the request made by the parties. The court will not get into examination of any other areas and other aspects, whether the arbitration agreement was valid, whether it was contract was valid, whether it is within limitation, outside limitation. So it's very important to have that practical understanding whenever you are making a Section 11 petition. Also, now recently there is a bill which is being proposed under the Indian Arbitration Act, where the requirements for appointment of arbitrator may now, which is a procedural requirement, will also be taken up by an institutional arbitration. So you can say that, okay, in case of dispute and the parties are unable to agree, the appointment of arbitrator can be done by an institutional arbitration like MCI or SIAC, etc. So this is a very important aspect that people should be aware of. Now, very important when we come in arbitration is to agree on the seat of arbitration. As you can see in my previous note, we have written that the arbitration seat will be Singapore. So what is the seat of arbitration? Many times people get confused between a seat of arbitration versus venue of arbitration, right? So seat of arbitration is a very important concept and is to be distinguished between a venue of arbitration. A seat of arbitration differs to the judicial seat. My venue means the physical venue where you can hold your arbitration, right? So venue can be anywhere in the world where the parties can decide it. And seat is the judicial seat through which the procedure of the arbitration will be governed. So for example, if I say the seat of arbitration is Mumbai, so or India, international, so Indian Arbitration Act will prevail. If I say the seat of arbitration in Singapore, so Singapore Arbitration Act will prevail. If I say the seat of arbitration is London, so the London courts will have jurisdiction on the English Arbitration Act will have a jurisdiction on the arbitration procedure which will be happening. So for example, if the parties are not agreeing for the appointment of arbitrator, so the court where the seat is there, that particular court will appoint an arbitrator. For example, if I say the seat of arbitration is Singapore and parties are unable to agree on arbitration, then they will have to write to the seat in Singapore court for the appointment of arbitrator. Similarly, if we want to seek any kind of interim relief under Section 9 of the Indian Arbitration, for example, Section 9 in Indian Arbitration Act, they have to apply for interim relief to that particular court having the jurisdiction over the seat. And also for the enforcement, we have to apply, or if I have to challenge the award, then I have to also apply within the same jurisdiction which has a seat. So very important that the seat of arbitration is well understood. It is not confused between venue versus seat. It's a very, very common mistake most of the companies make, where they understand that venue and seat is the same thing. They are two different things, right? Now, after having understood about the seat of arbitration, it's also very important to understand the governing law about the arbitration. So governing law is will be something which under which the dispute will be resolved, where the remedies of the parties will be considered, where the procedural law of the that particular governing law will be applicable when you conduct an arbitration. For example, if I say that the governing law will be UK with seat of arbitration in Singapore, right? So in that means that when it comes to appointment of arbitrator, enforcement, challenge, etc., it will be the Court of Singapore. However, when the parties are seeking remedies and procedures, etc., there the English Arbitration Act will prevail. So the arbitrator, assuming it's not a SIAC-led arbitration, then the English Arbitration Act will be referred by the arbitrator to look into, or English law will be referred by the arbitrator while looking for the remedies. Similarly, if it is says that, for example, Indian governing law of India, so while awarding damages, etc., the arbitrator will get into the Indian Contract Act in terms of looking into what kind of damages, etc., can order the remedies which are available under the Indian contract that will be required and can be given. So very, very important to consider these two important aspects: governing law and uh, versus the seat of arbitration. Many times people get confused with this, and it creates a lot of confusion. And in that case, dispute then arbitrators has to apply their own mind. If the contract is silent, that what is the governing law? So there are various principles which are applied. For example, if there is no governing law mentioned, probably the seat of arbitration may be considered as a governing law. Or then we will see the where the parties are residing, they will apply that governing law, or where the dispute of the property where it is resided, there they will apply the governing law. So arbitrator at that point in time has to apply its mind and has to give a proper reasoning of award, right? So now, having understood the requirement of appointment of arbitrator, how they are appointed, governing law, and the seat of arbitration, a very important aspect about the arbitrator is about its independence and autonomy. The thing that distinguishes arbitration compared to other ADR mechanism is the autonomy in which the arbitrator is there. Arbitrator is concerned as a judge, right? And therefore, Section 16 of the Indian Arbitration Act, which is also enshrined and taken from the unsettled model law, talks about the competence doctrine. It's a very important doctrine. This doctrine actually says that the arbitrator has authority to decide its own jurisdiction and nobody can challenge that, right? So it has full power to decide all the question of law. It has all the powers to decide its own jurisdiction as well. And this gives an immunity in terms of facilitating and undertaking the arbitration procedure. For example, once the arbitration tribunal has been constituted, assuming I have been appointed as an arbitrator, another party makes any allegation regarding any appointment procedure or any other aspect, I can rule on my own that no, I think that there is no conflict, the procedure has been properly followed, and etc. So that gives a immunity as well as gives what you can say certainty and authority that all the the process of arbitration will be followed, and I will have the arbitrator, it will have its own jurisdiction to decide on its own whether they have a power to decide this arbitration proceedings or not. It's a very important principle. In fact, there is a case law also in Uttarakhand Parva Limited. It's a Supreme Court judgment where there had been clearly stated that the doctrine of competence gives authority to the tribunal to decide matters concerning its own jurisdiction. And this includes all questions of law relating to jurisdiction as well as the existence and validity of the arbitration agreement. So uh, those power has to be exercised by the arbitrator very carefully. However, very important, if an arbitrator takes any order on its own jurisdiction, then that order becomes challenge under 37. So that's why in many arbitration proceedings, this is the practical side I am just telling to all of you. Whenever such kind of challenge is made, the arbitrator does not pass any order. Because the moment they pass an order, it becomes challenger on the 37. So most of the cases, the arbitrator takes a note that the jurisdiction challenge has been made. I feel that I have the jurisdiction, but I will pass an order regarding this in the final award. So this is some of the practical ways that you avoid. Otherwise, any arbitration interim orders which are passed, they become also challenged. This is very important principle, and the competence doctrine. Many there are case laws which are there, and this is the heart of the entire arbitration procedure. So unless until they have the proper competence to decide and jurisdiction to rule on its own authority, every other arbitration tribunal will become subject to challenge in the court of law, right? Uh, yeah. Okay. Now I will move on the conduct of the arbitration proceedings, right? So once the arbitration tribunal has been set up, the parties process starts, then the entire arbitration procedures starts. So it starts with the filing of the claim, then of course the statement of claims, then there's a counterclaim and etc., which are statement of defense, etc. These are filed. Then of course hearing happens and the evidence are led and the confidentiality, etc., are maintained. But in case of arbitration, what is the important thing is there? It gives a lot of flexibility to the parties to decide on the timelines, etc., assuming it's an ad hoc arbitration. In case of ad hoc arbitration, there will be a first hearing that will happen where the arbitrator will decide how the process of arbitration will flow. So, with the consent of the parties, the arbitrator will list out the procedures to be followed. So, it will agreed on certain timelines. Within the X number of days, statement of claim will be filed in X plus Y days. Statement of defense will be there. Counter claim will be there. Then hearing dates were decided. So there's an interim orders, which are procedural orders, what we call it. They will be passed where the parties will agree on those procedural requirements. But it gives a lot of flexibility. If an arbitration is governed under the institutional arbitration, for example, CIAC, LCIA, ICC, or MCIA, their rules provide the entire process within which the entire arbitration will be covered. So the rules will say within 45 days, the statement of claim has to be filed. Within 30 days, the statement of defense will be filed. XX days, hearing will be done. In X number of days, evidence will be led. So this entire thing will be governed by the secretariat of that institutional arbitration. So in that case, the arbitrator is bound to follow those arbitration rules and the procedures. However, there is a flexibility which is given with the consent of the parties. So with the arbitrator is bound to follow the instruction of the parties. And if both the parties are in consensus, they has to pass and has to follow those requests which are made by the parties. Of course, he has to record the reasons. And if he is not also agreeing, there has to record the reasons, because later on, otherwise, one of the parties will take this plea that I was not given proper opportunity to present my case, and that can become a ground for challenge once the award is passed. Another very important feature which is there in the arbitration is about confidentiality. Now, this is a very important feature which distinguishes an arbitration versus disputes which are resolved through courts. Because once the case are filed in courts, it becomes a public document. People can take, everything is there on the court website. In case of arbitration, the entire proceedings are kept confidential until the award is passed and it is filed for execution. So very important feature, and that's why most of the agreements like shareholder agreement, technical collaboration agreement, share purchase agreement. People prefer to go with the arbitration so that the proceedings, the disputes, if any happens, they remain in a private and they are not exposed to public, and the confidentiality of the disputes is maintained. Now, during the course of arbitration also, there are various procedures which are followed. And two important thing which is very important is about the interim relief. So there are two types of interim relief in an arbitration. One is Section 9 interim relief, and then there is a Section 17 interim relief under the Indian arbitration. Section 9 interim relief typically happens before the arbitration has commenced. For example, there is a dispute which has already started, and two parties are already in dispute, and arbitration tribunal are yet to be constituted. But uh, there is a fear that the other party may dispose of his assets, or it is doing something that will further prejudice the interest of the other client, or further create some damages, or the other party has to be restrained from doing something. In that cases, the parties can seek an interim relief under Section 9 of the court having the jurisdiction. Again, the seat of arbitration becomes important. So wherever the seat of arbitration is there in that particular jurisdiction, the other party will go and seek an interim relief under Section 9. And that Section 9 relief will remain till the arbitration tribunal had been constituted, so that the interests of the parties are protected. Second, interim reliefs, or which we call as interim measures more technically, where the arbitration tribunal also have similar powers, which is called under interim measures under Section 17. So once the tribunal had been constituted, then the arbitral tribunal gets the power to pass such interim measures. For example, the tribunal has been constituted, but resolution of dispute will take some time. Like under the Indian Arbitration Act, now there is a timeline of 12 months, which has been 15 months have been prescribed after the completion of the statement of pleadings, etc. But it will take some time. But meanwhile, for example, the dispute relates to any property, and there is a fear, not sorry, property, certain goods or certain other certain other assets, which feels that the other party may dispose of. So for that protection, the other party can seek application for seeking interim measures from the arbitration tribunal under Section 17, where the arbitration tribunal can pass an order saying that this property be kept till abeyance and no action can be taken for the disposal of this property. Or, for example, you want to secure your cost against those properties, so then you can also seek such interim measures. And for the protection of those awards, judicial assistance is also possible. So that particular order which is passed by an arbitration tribunal as an interim measures, that can be also enforced by the courts. We can seek assistance from the respective courts within the jurisdiction with this arbitration tribunal the seat is coming, and court can also pass direction for the protection of those assets by this interim measure order which is passed by the arbitration tribunal. So very important provisions of Section 17 dealing with interim measures and the orders. It is as good as a order which is passed by the civil court for protecting the assets as well as for the enforcement. Now, once the entire proceedings are etc. are over, then of course the final arbitration award is passed. Very important that the order which is with the award which is passed, it is a very reasoned award. When I say reasoned award, it means that the award should have the list of issues which the parties have agreed. So normally the list of issues are agreed between the parties at the start of the arbitration proceedings. So both the lawyers exchange the list of issues from their side. For example, the claimant will have 5 issues, the other side will have 3 issues. So then they exchange each other's list of issues and then they jointly agree, or then the arbitrator itself can agree ki, okay, these are the 4 list of issues. So the arbitration award should specifically deal with the list of issues. Each of the issues, what is his view, what is the evidence was led, what are the statements that have been recorded, who are the examiner in chief, etc. These are properly has to be recorded, and then a reasoned award is passed. Unless until the award is not reasoned, it becomes susceptible to challenge under the Indian Arbitration Act. Of course, the arbitration award has to be also passed within the timeline, which as mentioned under the Indian Arbitration Act. The timeline is 15 months, which can be extended for another period with the subject to the approval of the high courts. Similarly, for international arbitration, the respective rules will provide within how many years or days or months the award has to be passed. So the arbitration, the secretariat, they manage it, and then of course it has to be stamped, signed, etc. So these are procedural requirements. But one of the very important aspect of the arbitration award is that it's final and binding. So normally you would have seen that it always said that the award passed by the arbitrator shall be final and binding. When it says final and binding, it means that the arbitration award which has been passed, it cannot be modified, changed, etc. So recently there is a case law which I'll discuss where the Supreme Court has given certain exemption. Very recently on 7th March the order was passed. But normally once the award is passed, it is considered final and binding. And the only way it can be nullified is by setting aside the award. So there are procedures under the Arbitration Act where the other party can make an application for setting up aside the award under 34, and there are certain grounds which I'll cover, right? So once the award is passed, then the parties have two choice whether they can go for enforcement or they can do a challenge. When I say enforcement of the award, it means that the party will go and carry that award and enforce it through the civil court or the concerned high court. And normally it will enforce in the sense the court will go and pass an execution order where the assets will be attached or the parties will be directed to pay, etc. if they are unable to comply. So there's a 3 months time which is given. So the other part, the challenge can be done for an award within 3 months. So normally the understanding that within 3 months, the other party must comply with the award. If they are unable to do so, then the other party can challenge the award or they can apply for setting aside the award. As I mentioned that the award which is passed becomes final and binding. However, the other party can file within 3 months time for setting aside the award or a challenge of the award, right? Uh, Now, whatever the awards are, just a moment. Yeah, just a moment. Yeah, once the award is passed, then there are grounds which are there for challenge for the award, which I'll cover in, I think is there in the next slides. I'll take you through what are the grounds through it can be challenged. Typically, there are very limited grounds it can be challenged. For example, there is against the public policy or the party alleges that the evidence was not properly led. The other party was not given a proper opportunity to present his case. There's a patent illegality in the award. So there are certain grounds which are provided under the Arbitration Act itself. Okay. Now, seat we have spoken, section 11 we have spoken, interim measure we have spoken. Yeah, this is for the section 29 and 29B of the Indian Arbitration Act for the timelines within which the award has to be passed, which is spoke. And there is also a procedure for a fast track provisions where there could be emergency if there is a little bit of emergency, etc. There also parties can request the arbitration tribunal for disposable of the matter in a quicker turnaround time, which is provided in the Indian Arbitration Act, right? Okay. Now, very important when we are dealing with the arbitration is to deal with the conflict of interest. This is one of the major grounds which our parties use while contesting an award, contesting the arbitration. And one of the principles for the arbitration is that it should be independent. It should be free from bias. There should not be any conflict of interest. So very, very important provisions about there should be no conflict of interest and there should be no bias, complete, there should be impartiality in terms of dealing with the arbitration proceedings. Uh, Internationally, so under the Indian Arbitration Act also, they have prescribed the schedules where there are certain provisions which are made that when it will be considered there will be a bias or partiality, which I just mentioned to you, in terms of, for example, they are related, they are having pecuniary relationship, they hold any share, they have certain kinds of interest in the outcome of the award, right? Um, even appearance of bias is more than enough to bring the element of conflict of interest, right? So internationally, what happens that there is a IBA conflict. There is a international bar association which is there, which has prescribed various kinds of guidelines, which most of the arbitration tribunals do follow in absence of any specific provisions codified in the act. For example, on Indian Arbitration Act has also taken certain provisions from the IBA conflict of interest guideline, which I'll cover. So what is the requirement for an arbitrator? It's very important that arbitrator make a proper disclosure of any apparent bias or apparent, potential conflict of interest which is there, and that has to be disclosed at all times. It's not that at the start, but also during the proceedings, if there is any situation which has come, which an arbitrator feels that there is a conflict of interest, then he has to make an adequate disclosure. Non-disclosure can lead to the removal of an arbitrator also, and the parties can apply to the concerned jurisdiction of the court, stating that this is the conflict which has come, and the arbitrator can be removed, right? uh, Now, when we talk about conflict, there are two type of conflicts where called waivable conflict and non-waivable conflict. Waivable conflict of interest are those where, uh, based on the disclosure of the arbitrator, the parties with the mutual consent can waive those things. And non-waivable conflicts are those um, which cannot be waived with the consent of the parties. Now, this is codified under the IBA conflict of interest guidelines, right? So, waivable conflict of interest are basically where are very simple. For example, where there is a prior relationship with the parties, there is a prior involvement. For example, the same arbitrator has also an arbitrator in a similar dispute with another party. With this, he was one of the presiding officers, so he knows that. Or in the previous any dispute, he had provided any kind of advice, or he has some kind of financial interest. For example, he might be holding some shares, say 100 shares in a particular company, which is less than the material threshold, like 2% is something which is considered material. So in such cases where the arbitrator makes a disclosure, then the parties can give a consent that, okay, we understand that this is something which can give a waiver to that, and then the conflict can be waived off. But there are certain non-waivable conflict that even where the parties wants to waive, they cannot. For example, there is a significant financial interest. The operator itself holds a 20% in one of the companies, or he is indirectly related to his relative in the outcome of the dispute or in one of the parties. So those are non-waivable um, interest. Or, for example, he has he has acted as an arbiter more than 3 times. Now, under the Indian Arbitration Act, an arbitrator cannot act as an arbitrator in more than 3 arbitration concerning the same parties. So, if he's already completed that limit, then it cannot be waived off. So, these are the examples where conflict of where interest cannot be waived, right? So these are provided and codified. It's very important to have that understanding of this concept of conflict of interest, and on the top of the table you will see that there are three, red, orange, and green. In green, where the situations that there is no duty to disclose. For example, he's holding some relationship which is just not creating any impact. Orange is something that he has to disclose and the parties can waive. And then, of course, red one is where the parties, the arbitrator cannot act, or it can act with the consent of the party. So these are codified under the IBA conflict of interest the guidelines. If these are available on the website also, if anybody is interested, they can also read it. Now, when it comes to arbitration handling, what are the process that has to be followed? Normally, in case on arbitration, uh, parties are free, and the arbitrator typically free to determine how the parties would like to proceed with establishing their claim. But practically, and what happens is that Indian arbitration, because most of the arbitrators are retired judges, etc., they follow the principles of leading the evidence, which are codified under the Civil Procedure Code. So while the Civil Procedure Code does not strictly apply to it, but from the procedural compliance purpose, the principles of leading evidence, the principles of submissions, the cross-examination, affidavit submission, etc., all those procedures which are provided under the Indian Evidence Act and those which are codified under the Civil Procedure Code, these are followed in arbitration, subject to flexibility being given. So arbitrator will have certain flexibility. He can give waivers. He can allow the parties to divert from those strict procedures. So guiding principles are the CPC, but again flexibility is being provided for the smooth conduct of the arbitration, because arbitration is nothing but party autonomy. As I mentioned, it's very important that parties have autonomy in the manner in which they want to govern the arbitration. Of course, this remains subject to with both the consent of the parties, and arbitrator has to record a valid reasons if he is allowing or disallowing any specific request, because these will become later on grounds for challenge in during later, right? Now coming on to evidence, standard process, there will be documentary evidence where there will be testimony, there can be electronic evidence, and there could be an expert opinions also. So many times the arbitral tribunal will seek the assistance on experts, typically in case of assessing the damages, because many times it is not possible to assess exactly amount of damage. So there the experts are also taken on board. The experts can be appointed by the tribunal, or the parties can also appoint their experts, and each party then bear its own experts, and then the parties can exchange the experts' opinions, and the tribunal can take a view from that also. But the standard process which are followed is this. Now there is also a type of arbitration which is document only arbitration, which are typically used in case of online arbitration, which banks and NBFCs typically use, where there's a very short arbitration proceeding which happens through ODR mechanism, what we'll call, where only in documentary evidences are led. There's no hearings or testimonies, etc. is conducted. For example, in case of loan default, in case of securities market disputes which are there, which are small disputes. So the parties just exchange the documentations, and on the documentation basis only the tribunal takes a view and decides, without getting into a detailed procedures of testimony and oral evidence and etc etc etc. So but the process which are applicable under the Indian Evidence Act in terms of witness testimony, expert opinion, examination in chief, etc., are typically followed in proper arbitration, which is there, right? Okay, so in the interest of time, so these are the entire process which I've captured, but I think it's a complete Indian Evidence Act procedures, that there will be pleading, then there's a discovery of documentation, then hearing, then submissions. So typically in discovery of documents, each party will exchange the list of documents that they have, requesting the other parties to share the copies, the documents on which they are relied upon. The other party will also. So based on that, the discovery of the common dispute-related evidences are, ascertained by the tribunal. So these are entire process. I'm not getting. Of course, then there will be examination and cross-examination. Each party will be given at the start of the arbitration, and how many, witness they will like to examine. So they have to give their name. So there will be examination and of course cross-examination by both the parties. So those all entire process are typically followed. This is documentary evidence, which I said only document evidence basis can also be resolved, right? Okay, so I'll not get into, yeah. So this is also, there is also an RBA rules of evidence. This is also one of the best practices which are followed and adopted by, where the burden of proof is also, of course, on the claimant, and the principles of fairness and confidentiality has to be followed while we are doing the arbitration. Now, we have appointment the arbitrator, then there's evidence has been led, the award is about to be passed. So very important aspect is cost. Awarding cost in arbitration is very, very critical and very, very important element, especially in international arbitration, because the international rule is cost follows the award, meaning whereby the person who has lost the arbitration, he has to pay the entire cost. So cost can be the arbitrator cost, the counsel cost, the expert opinion cost, the cost for conducting arbitration, venues, etc. So the party who is losing typically end up paying the most of the cost, which is spent by the parties in contesting the arbitration. And when you file your claim, statement of claim, you make a plea that if the award is in their favor, then appropriate cost should be awarded to the winning parties. So very important, awarding of cost is most of the arbitration, about 65 to 70% of the cost are recoverable, depending on the stages and the process which has taken, and of course the arbitrator will take a final call in terms of how much award is to be passed, right? So, but typically cost will include the fees of counsel, the arbitration fees, etc., which are then of course the interest. So interest is also a very important element. Arbitrators have power to award interest, provided the contract says about awarding of interest, or the Arbitration Act under which the proceedings are there. It talks about for awarding of interest. It can be pre-arbitration award. It can be post also. Pre, it means that from the date of dispute or date of dispute till the date of award. For example, the dispute have arisen on 1st April 2020. The award was passed on, say, 31st May of 2025. So from that period, pre-award interest will be provided. What rate and etc. that has to be as per the Arbitration Act in which the arbitration has been governed. If the Arbitration Act is silent, then the arbitrator typically should not be awarding any interest. Similarly, post-award interest is also there. For example, the parties must complete and comply the award within 30 days. If failure, that X number of interest will also be there on the final award. So both the interest can be is applicable, right? So as I mentioned, the principles of awarding cost is that cost follows the award. So the successful party is generally entitled to recover the cost. The proportionality has to be has to be judged, which is again the arbitrator decide, and of course additional cost can be awarded based on the conduct of the parties, etc. Right. So yeah. So the okay, now we have the process completed and everything done. Now the award has been passed. Now section 37 is something which I was mentioning earlier. Yeah, first I'll cover 34, challenge to the award, which I was mentioning, that once the award is passed, so then the other party has can make a challenge to the award. When they say challenge to the award, if you remember, I mentioned that once the award is passed, it is final and binding. So what does mean that the award cannot be cancelled. It can only be set aside. Set aside, it means that the order has to be challenged under 34 of the Indian Arbitration Act. And the challenge ke liye you have to file that application within the court which has the jurisdiction where the seat of the arbitration is there. But there are only very limited ground on which the award can be challenged or set aside, which are provided under section 34, which is, for example, invalidity of the agreement or incapacity of the parties. It meant the arbitration agreement itself was not valid. For example, recently last year, there was a case where the arbitration agreement was not properly stamped, right? And the other party which lost the case, they went and filed a challenge to the award, and in fact the matter went up to Supreme Court, and they held that non-stamping on arbitration actually is a invalidity and no award can be passed. Of course, later on the review petition, the Supreme Court said that okay, it can be regularized upon payment of the stamp duty, etc. So if these types are there, then that can be ground for challenge. Lack of proper notice or opportunity, very important. If the other party alleges that it was not given proper opportunity to represent its case, the award itself has exceeded the scope. The tribunal was not properly constituted. For example, the tribunal itself was under certain kind of disqualification. Dispute were not arbitrable. For example, it was a fraud or a competition matter, or there is a conflict with the public policy of India. Now, this is a residual clause. Uh, for example, there are certain types of disputes which are not arbitrable. For example, marriage related, for example, so certain competition law, for example. So some of these things which are against the public policy of India, that is also one of the ground on which the tribunal will be, the other party can challenge the award. Now, after the BCCI judgment which has come, so there is no automatic stay, right? So earlier there was an automatic stay prior to the amendment of 2015. But now, whenever you file an application, then what happens that 50% of the amount typically has to be deposited, and there is a stay. There is no automatic stay, and of course, the parties then keep on arguing, and the court can decide on the setting aside the award. Now, this is a very interesting thing because if you recall in the start, we said that the award is final and binding. But there has been various cases and various instances where the courts had been interfering in modifying the awards. For example, they will reduce the interest, they will give some relief to the parties, and this has been under challenge. And there are two school of thoughts to that. One school of thought says that is an arbitration once final, then courts cannot modify; they have only power to set aside. The other school of thought is that no, power to set aside should also have the power for modification if there is certain thing where in the interest of justice it is important. Now this debate has been going on for many years. Now recently in March 25, this matter has been finally settled in Gayatri Balasmi versus ING Novasurf Technologies Limited. And interestingly, it's a 4:1 judgment where it's a 5-bench judge and one of the judges dissented from that. But the majority ruled that the power to set aside award also have limited power to modify. So court has held that Supreme Court has held that courts will have a limited power to modify the award, but only to the extent it is necessary uh, for the for ensuring the effective implementation of the award, or if any part of the award is illegal in nature and has to be severed from the other part. So for that limited purpose and to do the justice, then courts can have limited power for modifying the award in the interest of the parties. Now, this is a very latest judgment. We'll have to see if how these judgments are applied in the future. But this is now a settled principle as of March 25, where the court has now held that the courts will have a limited power. Now, this has seen something very also, there is one school of thought internationally. Many jurisdictions do not provide powers of the court to modify the award because again it goes back to the principles of New York Convention and Uncentral Model Law, which you say that courts will have very limited intervention only when Section 9 or Section 11 requirement are there, or Section 17 interim measures has to be protected. The court otherwise should not have power. But with this, Indian courts have assumed power for modification. Like Singapore courts or Singapore Arbitration Act do not have such provisions. So this is a really interesting to see how things go ahead. Now, Section 37 also deals with certain provisions where the certain orders of the tribunal can be subject to appeals. So these are not the award; these are not the final awards. But this is for example, I mentioned that certain interim measures were passed. So the other party can file an appeal under 37. So this is pre-filing of the award. Once the award is finalized, then setting aside is under 34. 37 is where you can challenge an interim awards. Or for example, there is an order which tribunal says that I have the jurisdictions, or they have ruled on something. So those interim awards, interim measures, interim orders can be subject to challenge under 37, and it has to be dealt differently under 34, right? Uh, Another important concept is about doctrine of group company. Now, this is something has been in discussion, especially after the judgment delivered in the Cox and case. Normally, as I mentioned, that arbitration agreement has to be in writing and it binds only the parties which has executed the arbitration agreement. But doctrine of group company actually lifts the corporate wheel, and non-signatories to the arbitration can also be included as a party in an arbitration dispute. So this is the case which was initially discussed under Kunro controls, and in Cox and Kings versus SAP India, this was finally held, and now Supreme Court and various courts are applying this doctrine. For example, there is a holding company. It has entered to a contract with a supplier of goods. So and the supplier who is providing the goods, there are beneficiaries which are subsidiaries of those holding companies, which has happened in case of SAP India also. So this doctrine of group company says that now there is a dispute. So strictly speaking, the dispute has to be between the holding company and the supplier of the good, because the contract is between these two parties and the subsidiaries are not signatory to this agreement. But the doctrine of group companies, court has said no, even non-signatory to arbitration agreement can be made parties if there is sufficient evidence to demonstrate that they are the ultimate beneficiary uh, arising of this agreement or to the dispute which is coming into play. So if they are able to demonstrate that the other party is able to control the arbitration, or for example, if the agreement is between subsidiary and the supply and the holding company which is governing the entire contract, they are having the beneficial ownership, etc. So in that case, the other parties which are non-signatory to the agreement can also be taken into as a party and can be implemented as a party to this arbitration dispute. Of course, this doctrine of group company has to be applied by the courts. So the court will determine whether this doctrine of group company will applicable or not. It does not apply automatically. So very important doctrine, and as a learning to all the practitioners, whenever you are doing any kind of agreement, to ensure that your group companies, subsidiaries, associate, holding company do not get caught in this doctrine of group company, please ensure that you specifically write in the agreement that this doctrine will not apply. The dispute will be only between these two parties. There are no other beneficiaries who will be subject to, so that if tomorrow the other parties tries to invoke, you can demonstrate that this doctrine of group company will not be applicable because there is already has been excluded in the contract. Now, enforcement of foreign awards, very important. So chapter 2 of the Act deals with the enforcement of the foreign awards. So this is very similar to 34 only. So all the foreign awards which are passed, which are in the new where India is signatory, those awards are enforceable in India as a domestic award, and these awards can also be subject to challenge, similar like 34. So I'm not repeating. The grounds of challenge to a foreign arbitral award is similar to a domestic award on the 34. We have 5-10 minutes. We can. So I'll just.
Thank you, Amber. Actually, we have received few questions in the chat box. So can we answer them?
Yeah, we'll take those questions. Yeah.
Okay, yeah. So first one we have received is how does arbitration and conciliation work in the cases of financial fraud or mis-selling?
So as I mentioned that frauds per se are not arbitrable. So if the other party is saying that there is a fraud which is there, then and there's an agreement between the two parties, then this will not be taken into arbitration. Mis-selling is another thing. It is not equivalent to fraud. And for mis-selling, etc., there is already a separate rules which are provided by various financial institutions. For example, there is an insurance ombudsman where the ombudsman can decide on the any kind of complaint which are coming through mis-selling. There are banking ombudsman. There are NBFC ombudsman. So mis-selling is not treated equivalent to fraud. So for that, these are remedies which are already provided under the respective regulations.
That was insightful. So the next one is that I would like to know that how do you see the future of online arbitration evolving in India? especially post-pandemic, and what legal safeguards should be considered?
Yeah, very good question. So ODR mechanism has gained very prominence, especially after the COVID. It was not that it was not there earlier, it was also there earlier. But post-COVID, ODR mechanism had gained a lot of importance. So, for example, I am from stock exchange. In the case of stock exchanges, the SEBI has already introduced an ODR mechanism where the entire dispute related to securities market is governed through an ODR mechanism. And there are ODR institute which are impaneled with the stock exchanges, and anyone who is desirous, when they file their complaint, they can select the ODR institute through which they can complete their arbitration proceeding. And of course, before that, there is a conciliation also. Similarly, now banks and NBFCs are also effectively using an ODR mechanism for resolution of disputes. However, there are certain limitations on the ODR mechanism, because as an ODR mechanism, if the matters are of very complex nature, it involves substantive issues. So many times through ODR mechanism may not work to that extent. But having said that, ODR mechanisms are working very fine where it's only a document-led arbitration is only there. For example, NBFC banks, they are now extensively using ODR mechanism for enforcement of matters where there is a default in payment of EMIs, there are default in payment of credit cards. In case of securities market, which is now mandatory. Now all SEBI has made it mandatory, the ODR mechanism. So it has a lot of potential when it comes. And internationally also, this ODR mechanism is working well, and we are seeing a good traction in the ODR mechanism. Yeah.
Hi, good evening, Amber. Josefa Unwala here from JHS Mumbai office.
Yes, sir.
Deepika, I had one question in the interest of, so many youngsters attending Amber's session today that, see, we are a firm of chartered accountants, Amber, and there are a lot of trainees who go on to become chartered accountants and lawyers, etc. And they are looking out to, explore new avenues, make career choices little different than the normal auditing profession. So this is a very interesting evolving subject. So any career specific guidance in terms of a person has to be a lawyer to take up arbitration work, or are there any degrees available that people can, pursue, or any good books that, they could read up during their articleship days, would go a long way in helping, make up their minds towards this career choice.
So, sir, in case of arbitration, there are two types of career choices that can be taken. One is that you become an arbitrator, right? So, to become an arbitrator, there is no qualification which is prescribed. It is not necessary that you should be a lawyer. You can be a specialist and become an arbitrator. And in fact, internationally, most of the presiding arbitrators are non-lawyers, because if there is a construction dispute, they will like to have an engineer who preside the arbitrations so that he understands how the construction industry work. Similarly, if it is an issue related with merchant navy related, or something on related with high seas, etc., many seamen and many captains, they become an arbitrator. So there is no such qualification who can become an arbitrator. But practical is that typically when the parties go for an appointment of arbitrator, they would prefer someone who has done law, who understands the procedural law, who should be somebody who has done practice of law, or of course, judges are somebody who is always preferred. But beyond judges, people go for somebody who has been a lawyer. In fact, when you go for Section 11, the courts typically appoint somebody who is a lawyer. So if you have done a law, etc., then of course the chances of getting appointment of arbitrator increases. In the Arbitration Act also, I think Schedule 6 or 7, they have prescribed various qualifications that who can be an arbitrator. Somebody who has practiced law for 10 years, even a chartered accountant, I think, and company secretaries have been also listed. So basically, somebody who understands the technical part can become an arbitrator. The second part is the counsel, where you have to argue the case on behalf of your client. So there, of course, there are a lot of avenues for lawyers who have done law, and they can become legal counsels for the purpose of presentation of their cases before the arbitration tribunal. And now recently, last year, in Arbitration Bar of India has been constituted. Like we have normal, Advocates Bar of India, Bar Council of India. Similarly, last year, an Arbitration Bar of India has also been, it's a non-profit organization which has been constituted in order to promote the arbitration, regime in India. So there are good avenues, and of course, non-lawyers can also become arbitrators if they have good knowledge and they have a, understanding of subject. But of course, it's a small industry, so people should know you, that you are an expert. And of course, like every industry, it has its own peculiarity. You need to know people. You should be in the market. And then, of course, you can also get yourself impaneled with various arbitration institutes. As over a period of time, institutional arbitration might get prominence after the amendment bill is passed, where all the appointment of arbitrator can be undertaken by the arbitrational institute. So if you're impaneled with an arbitrator institute, so you can get a preference. So good scope, if you have an deep interest in that.
Thank you so much, Amber. Thank you so much. Deepika, on to you.
Thank you, Zafar sir. Thank you, Mr. Gupta. I hope all of you must have gained a deeper understanding of and the benefits of application of this alternate dispute resolution mechanism. And these takeaways will surely be valuable in all our professional journeys.
Yeah.
I'd like to
Sorry, I have
explain.
because there are more presentations, but I think interest of time we'll have to follow, because 1 hour is very difficult to cover.
Yeah.
Because I've covered about conciliation also, then I've covered about DIFC and how the international courts of DIFC etc. works. But maybe I'll circulate these presentations to all of you, and then
So
Yes,
Deepika,
yes.
my request is
Yeah.
maybe in another 5 minutes, if Amber would like to conclude in another 5 minutes his presentation
So
slides.
quickly about the
You can.
conciliation. So conciliation is provided in the chapter 3, and it's basically where the parties just agree and appoint a conciliator to resolve a dispute. Now, conciliation is a very non-binding thing. It's something which parties can offline kind of thing. It's non-binding, and it is not something where it's a judicial process. So typically, conciliator is also an independent party. It's like very synonymously used like a mediation, which I has told you, but it's little different from mediation, because mediation now becomes binding. Now after the Mediation Act, which has also come, conciliation is more. For example, in case of stock exchanges also, whenever a dispute comes, conciliation is mandatory. So first, the conciliation is initiated and helped by the stock exchange itself, where they try to resolve the differences between the party through a conciliation process, where the parties can enter into a dialogue and etc., and then can arrive at a common, agreement, something like that. In case the conciliation fails, then it goes to arbitration. So that's the major difference in that. And the main difference between both of them, it's more conciliation, more facilitative, with more informal. It's all about opening a dialogue. And arbitration is more of a process, which is a formal process. It has powers where the orders are subject to judicial reviews. There's the Indian Evidence Act, as I told you, all those things are there, and the outcome is final and decisive. It attains finality when the arbitration is passed. But that's the conciliation difference. Now, I think DIFC also I was told to cover. So DIFC as it's called a Dubai International Financial Center. So it is like very similar like a gift city which we have in Gandhinagar. It has its own arbitration institute. It has its arbitration rule. So like very similar like a gift city that we have. So it has its own arbitration provisions. Even in gift city in India, Ahmedabad, last year there were draft rules for gift arbitration has been specified. So all the disputes which are arising for the companies which are operating within DIFC, they have to follow with that. And there is a local DIFC court also, which try and resolve these kinds of issues which are arising for contracts and dispute which are arising between the companies or parties which are operating for Dubai International Financial Center. It is little different. UAE court per se will not have jurisdiction. Only the DIFC court will have, and it is based on the common law, which is the English common law. So it has a worldwide acceptance. and the rules, etc., is also based on unsettled model law. So a lot of international companies with which they operate out of DFC, or for example, international contracts are happening. One party is in DFC, another in say India. They can agree for a DFC resolution dispute through a DFC. It has its own rules. It's very similar like a institutional arbitration mechanism, which we follow all the rules. So this I just wanted to cover for the information of all. That's the end from my side. I think we are already 7, so yeah.
So the topic is such vast that maximum was required to be covered, but it was a beautiful session and a lot of insight we got. And as we conclude this 30th edition of the JHS Excellencia Series, I'd like to thank Mr. Gupta for sharing their valuable insights on the arbitration and conciliation. I would also like to extend my heartfelt gratitude to the organizers and the participants for making this session a success. And looking forward to your continued engagement with the JHS Excellencia Series. Stay tuned for the future sessions.
Thank you so much,
everyone.
Thank
Mr.
you.
Upeza
Thank you
and
so much, sir.
JSS for inviting. If anybody has any questions, etc., they can drop in an email to me at ambergupta78@gmail.com, or they can write it to me on LinkedIn. So whatever within my knowledge I have gained in little bit, I'll be happy to share. And also if somebody is really interested in arbitration, they can also obtain a certification from a chartered institute of arbitrators. Like I'm a fellow of CIRB. It's a premier institute which provides the certifications in international arbitration. There is no such institute as of now. There are in India also there are, but not to the level of CRB. So if anybody is interested, they can also do a fellow certification of CRB if they want to do. Yeah. So thank you very much, and I hope I was able to do justice to the session. And look forward to future engagement.
It was a really wonderful session, and many of our team members, our clients and friends always come back with a request that can we have the PPT of the presenter as a record. So if Deepika can have a copy of that, then she can circulate it to him.
Sure.
Yeah, I'll send it to you.
Thank you.
Thank you.
Thank you so much,
you,
Amber. Thank you so much. Wonderful
Have a
session.
good evening.
Wonderful session. Yeah.
Thank you so much, sir.
Thank you, sir. Bye.
Thank you, everyone. Have a great evening ahead. Bye-bye.
Bye.